It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show.
Hey, tired of being Mr. Nice Guy to these fuck niggas. Got nothing to discuss with them unless it's about business. I replenish when they all diminish. Started caking, I ain't near finished. Can't kill him, I been too kind. When the money pile, I need y'all to witness. Pull up on them like calisthenics with the juice on me. Met your chick, she amused for me. Sent music to amuse. I was not enthused when they put the blues on me. Wait, fuck that time for me to bust back. Show me where the love at, ho. Niggas on the block with the gun strap. Homie finna dump that. Hit him where his mustache go. Ayy, get on my level. When it come to bank, I pimp my teller. Never been a nigga that'll rock Margiela. Never come around, I bitch, y'all better. Might not ever get the rock Coachella. I don't get no fucks, I do you one better. I'm about my cheddar, don't sprig no feather. I skate on track like Bam March. Every young nigga too hot, don't need no leather. I've been the living legend for a minute. I was at Apache trying to sell a ticket. Nigga used to rap when Debo had the bitches. I've been learning about the boss and treated like an auction. Labels gotta bid it. I ain't never been with Stallion. I can make a call and get the money printed. Bitch, I do not play when it come to this rapping. Studied the game when I lived in the attic. All of that struggle just made me a savage. Singing my praise on my edge, it been jagged. Hating that nigga can't fit in my jacket. I give you that shit, y'all nigga be taking. Y'all bite my style straight trash. Y'all make it to 21 day, make stuff my habit. I'm gone.
What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there this evening. In this video, we're going to be getting into Megan Thee Stallion and the DJ that don't spin, all right? This weekend, we got hit with some new information that is showing that Megan Thee Stallion is petitioning the courts in New Jersey, where the DJ that don't spin resides. They've sent in a motion to compel, meaning that they want to force him to have to testify in this case with Megan and Milagro. Now, the reason why is because the DJ that don't spin, Milagro, people like Adam 22, Aiden Ross, there's a select few people who create content or speak about entertainment news, run podcasts, content, etc., that have been parroting a lot of information that is seemingly coming from Tory Lanez. People have alluded to a police report or record of Megan Thee Stallion stepping on glass, which was a record that was taken down before surgery was actually conducted on her foot to remove the fragments out of her feet. But people have been using that report, and this dates back to 2022, referencing it, saying that Megan Thee Stallion lied on Tory Lanez, she was never shot, etc., etc. Now, what I want to understand is, in that very same report, it says that there was 5 shots fired and that the last person that had the gun, based on the proximity and everything, was Daystar Peterson, aka Tory Lanez. But nobody talks about that part in that very report. It says who shot the gun. But this report was also sealed for a time, but for whatever reason, it ended up in the hands of content creators, bloggers, etc., or a select few of them, I should say. Right? Now, from Megan Thee Stallion's purview, she believes that this information was sent from Tory Lanez or people affiliated with him to create a media narrative against her, a hate campaign against her. And they've been taking down information, logging it for quite some time. And we're going to get into all of the documents that have been submitted about this whole situation. It's 183 pages, as a matter of fact. I'm going to do my best to get through them as swiftly as possible. It's a lot to get through, but shit is definitely heating up. I believe when the DJ that don't spin was brought in to answer questions during his deposition, they asked him where he was getting his information from. He said that he would never reveal his sources unless he was forced to testify. So Megan Thee Stallion and her legal team are saying, okay, if those are the parameters in which you'll speak, let us expedite that process for you. All right, let's get to it. So here we have the paperwork pulled up. This is Joanna Manillo, Esquire, from Quinn Emanuel, which is, of course, the law firm representing Quinn Emanuel, Urquhart, and Sullivan, the law firm representing Megan, John O'Sullivan. And we have here Marie Harapetition, all right, pro hac vice to be submitted from Quinn Emanuel. Here, it's a motion to compel Livingston Allen to comply with Rule 45 subpoena for the United States District Court of New Jersey. Please take notice that upon the accompanying memorandum of law and the declaration of Joanna Manillo, dated September 16, 2025, and all the exhibits thereto, petitioner Megan Pete, by and through her undersigned counsel, will move this court on a date and time to determine by the court for entry of an order compelling compliance with subpoena to third party Livingston Allen, aka the DJ that don't spin, pursuant to federal civil P 45 in connection with the action pending in the United States District Court for the Southern District of Florida, captioned Megan Pete v. Milagro Elizabeth Cooper, aka Milagro Grrrls. Petitioner hereby certifies that petitioner's counsel in the underlying action in the Southern District of Florida has attempted to secure Livingston Allen's compliance with the subpoena in good faith as set forth in the accompanying declaration of Joanna Manillo. But such efforts have not been successful, as Livingston Allen has not produced the documents commanded by the subpoena. Okay, so he's not cooperating with the subpoena. Please take further notice that in support of this motion, petitioner Megan Pete relies upon the accompanying memorandum of law, declaration of Joanna E. Manillo, and all exhibits thereto. Please take further notice that oral agreement is requested if this application is opposed. Okay? So oral argument would mean that they would have to come before a judge and hash this out. Or at least get good reasoning as to why, right? This is the Joanna Manillo signing off. We can move forward. Certificate of service, blah, blah, blah. So here is their civil cover sheet. They want to, basis of jurisdiction is federal questioning. Okay, some of this stuff is very small. But we're just going to make our way through this. All right, we got a table of contents here. We're going to skip through that. Here is the preliminary statement. This motion arises from Livingston Allen's deliberate obstruction of discovery in a defamation and harassment lawsuit pending in the Southern District of Florida against Milagro Cooper. Cooper, an internet personality, has waged a years-long campaign to smear and intimidate petitioner Megan Pete, professionally known as Megan Thee Stallion, in coordination with Miss Pete's convicted assailant, Daystar Peterson, aka Tory Lanez. Allen, better known as the DJ that don't spin, was subpoenaed to testify about his role in amplifying Cooper's defamatory statements. At his deposition, Allen flatly refused to answer the most critical question: who provided him with DNA evidence that he and Cooper simultaneously announced on social media at a time when it was under a protective order and available only to prosecutors, Peterson and his counsel? Cooper herself confirmed that she and Allen had the same source of that information, but was unable to recall where it came from. So she said, we got the same source, but I can't remember. Right. And Allen confirmed he received the information through an exclusive, but refused to name the source. Identifying this source is essential to proving the coordination between Cooper and Peterson and exposing Cooper's intent for perpetuating false and demeaning claims against Megan Pete. So for the people out there that feel like this is a so-called fishing expedition, right? We're drawing parallels between Milagro and the DJ that don't spin, saying if they're putting out the same information at the same time and it's allegedly coming from the same source, which both of them refuse to disclose via depositions, then we need to get to the bottom of this, because this actually shows coordination leading back to Tory Lanez, the only other person outside of Megan and his legal counsel that were permitted to have access to said documents. Rather than answer, Allen insisted that's something he would never reveal and attempted to hide behind a claim of journalistic privilege. But under questioning, he admitted that he is not a journalist. Interesting. You claim journalistic privilege, but then say you're not a journalist, which we know you're not. He has publicly disclaimed the title, invokes it only when convenient, and describes himself instead as an online streamer and entertainer. When that pretense collapsed, Allen abruptly shifted course, claiming he could no longer recall the very source he had moments earlier vowed never to reveal. His testimony was evasive, contradictory, and obstructive. Allen has also failed to produce a single responsive document, including correspondence, showing how he obtained DNA evidence before it was revealed. Without Allen's testimony and documents, Ms. Pete will be denied access to critical evidence of Cooper's defamatory intent and coordination with Peterson. The court should therefore enter an order compelling Allen to produce documents responsive to Ms. Pete's subpoena and sit for another deposition where he must answer the questions he improperly refused. Footnotes here say Ms. Pete respectfully requests that any redeposition be supervised by this court and occur in person to ensure Allen respects the process. During his deposition, Allen provided non-responsive and evasive answers clearly designed to create content for as many followers as he professed he would do prior to his deposition. And we saw that he released footage of his deposition to his followers on social media and on his channel. All right, claiming he would put his own deposition out because it was content for him. And when asked whether he was recording his deposition, other than identifying 2 surveillance cameras behind him, he answered in the negative. So when they asked if he was recording, they said no, but he said he was going to put it out, which clearly stated he intended to record. Nevertheless, he secretly screen recorded the proceedings and made good on his promise to post it online thereafter. Got an Instagram reel here, which I will not click on. Directing redeposition under court supervision, where deponent failed to answer questions propounded at his deposition and provided evasive and non-responsive answers. Okay, we get into some factual background here. I think we all know who Megan Thee Stallion is. We know who Milagro is. So I don't want to spend too much time repeating what's already known. So they say here, discovery in the litigation has confirmed what Miss Pete knew to be true from the start. Peterson, as in Tory, and his father enlisted and paid Cooper to amplify these defamatory messages, provided her money, misinformation, and access. And they encouraged her to act as their public mouthpiece to circumvent a protective order against Peterson and court-ordered gag restrictions in the criminal case. What's more, in the moments before the Florida action was filed and while it was pending, Cooper engaged in an elaborate cover-up by deleting thousands of messages from her phone, which are now the subject of a spoliation motion before the Southern District of Florida. Peterson, too, did his part by being so obstructive in his deposition that he has been ordered to sit for a court-supervised deposition, which he once again refused to take part in because he would not answer, and his lawyer said, "We're not doing it." Now back to Mr. No Spin. They say his knowledge of Cooper's scheme. Cooper and Peterson, however, are not the only witnesses with knowledge of their scheme. On February 23rd, 2022, Cooper stated in a live stream that she and Allen had the same sources for misinformation she spread about the evidence in Peterson's case. Allen considers himself to be a streamer and media personality, among other things, who self-reportedly streams about music, urban topics, hip-hop specifically, music industry stuff. Like Cooper, Allen made biased social media posts about Peterson's case, promoting the narrative that Peterson was innocent and his accuser, Ms. Pete, was lying. On the morning of February 23rd, 2022, just before Cooper's live stream, Allen and Cooper posted the exact same update to Twitter. Breaking. It was revealed in court few moments ago that Tory Lanez DNA was not found on the weapon in the Meg Thee Stallion case. This was false. The DNA evidence had not yet been presented in court. And as Peterson's own defense attorney later admitted, the results were inconclusive. They neither identified Peterson nor ruled him out. All right, so I believe it was 2 hours before they had even gone into the courtroom to identify said DNA evidence. The DJ That Don't Spin and Milagro Grrrls had both put out breaking news of a revelation before it was even brought up in court. Significantly, the DNA evidence was non-public and accessible only to the parties in the criminal prosecution when Cooper and Allen published their identical posts purporting to interpret that confidential document. But circulating these erroneous posts was not merely premature publication. Both Cooper and Allen disseminated false characterizations of evidence months before the trial even began. Ms. Pete seeks discovery to prove that Peterson or his surrogates leaked that information and perhaps even suggested the language of the tweet to Cooper and Allen. Allen's failure to cooperate with discovery. On July 22, 2025, Ms. Pete subpoenaed Allen, and on August 22, 2025, she attempted to take his deposition. Allen appeared via Zoom without counsel and refused to provide meaningful testimony on his common source with Cooper. When asked about the source behind the tweet at issue, he flatly refused to answer, insisting that's something I would never reveal unless compelled under a court order. Very interesting caveat now that we're sitting here. Allen first attempted to shield himself by claiming he was a journalist, but then conceded that he only considers himself a journalist at times. Has publicly disclaimed being a journalist and admits he invokes the title only when it suits him. After the record established that Allen does not qualify as a journalist, he abruptly changed course and claimed he could not recall the very source he had just refused to identify. The next day, Allen released a surreptitiously screen-recorded video of the proceeding on various social media platforms, including Instagram and Kick, mocking the process and disclosing questions posed to him. And despite admitting that he had material responsive to the subpoena request he received, Allen has not produced a single document, including his communications with Cooper or the very correspondence in which he received the document underlying his February 23rd post on X. Without Allen's testimony identifying his shared source with Cooper, and without the documents he was subpoenaed to produce, Ms. Pete risks being denied access to critical evidence linking Cooper's defamatory campaign directly to Peterson. That evidence is essential to proving Cooper's intent for spreading false and demeaning statements about Ms. Pete. Okay? Legal standard. Rule 37A3B permits a party to move for an order compelling an answer where a deponent fails to answer a question asked under Rule 30 or 31. Federal R Civil P 37A3BI. Furthermore, an evasive or incomplete answer must be treated as a failure to answer. Accordingly, a motion to compel the additional or continued deposition of a deponent will be awarded where the deponent provided evasive and non-responsive answers to questions. They say if the motion is granted, the court must, after giving an opportunity to be heard, require the party or deponent whose conduct necessitated the motion, the party or attorney advising that conduct, or both, to pay the movant's reasonable expenses incurred in making the motion, including attorney's fees. So all y'all motherfuckers finna be paying Megan's legal fees for wasting her motherfucking time. So y'all could keep dragging your feet. Y'all could keep not submitting information after being subpoenaed, documents, etc. All of the billable hours that Megan is investing into this, y'all just gonna end up paying for it anyway. She's gonna hit you in your pocket. Y'all feel like y'all rich? DJ That Don't Spin got a good amount of income coming in. I don't know about the other one. We'll see how it goes. Granting motion to compel deposition testimony where deponent was improperly instructed not to answer certain questions that had not been asked and spoke words but did not provide answers, thereby preventing effective examination. Okay. Whereas here, the question at issue concerns a claim of privilege. The propriety of that assertion may be determined on Rule 37A, motion to compel. After a deponent invokes the privilege, proper procedure is for party seeking discovery to file a motion to compel. So they're just following the protocol. Allen should be compelled to sit for redeposition because he cannot avail himself of protection under New Jersey Shield law. Allen is not entitled to invoke the journalistic privilege and must be compelled to provide testimony on the questions he refused to answer. By his own admission, he is not a journalist and cannot meet the elements to qualify for protection under New Jersey's Shield law. The Shield law puts limits on discovery for a person engaged in, connected with, or employed by news media for purpose of gathering, procuring, transmitting, compiling, editing, or disseminating news for the general public. So if the DJ that don't spin was a legit journalist, he possibly could use New Jersey's Shield law. But because he admitted during his own deposition that he is not, they're saying he cannot hide behind that shield, or the Shield law, that is. They say New Jersey provides certain free speech protections only to the press. The witness asserting the privilege has the burden of proving they are a member of the press and therefore qualify for the protections of the Shield law. The proponent bears the burden to prove the privilege's application to any given situation, but the mere claim that one is a reporter or journalist is not enough to gain the protection of the Shield law. Here's another footnote. They say the Florida court found that defendant Cooper, who uses social media platforms similar to Mr. Allen, is not a journalist for the purposes of Florida law. Remember, the judge said that. She doesn't qualify as a journalist either. Nothing about this alleged conduct suggests an effort to impartially disseminate information. The allegations thus depict a campaign, not journalism, and the court cannot find that defendant is a media defendant entitled to protection under Section 770.01. Citations omitted. All right. So, rather, a claimant of the privilege must demonstrate 1. A requisite connection to the news media, 2. The necessary purpose to gather or disseminate news, and 3. That the materials were obtained in the course of professional news gathering activities. Allen cannot meet this burden. He describes himself as a streamer and entertainer, has publicly disclaimed being a journalist, and admit he only uses that label when it benefits him. Simply put, Allen's attempt to shield himself behind the press is a pretense, and the court should reject it. Allen does not bear the requisite connection to news media. Allen's online presence as a streamer does not qualify as news media. The Shield law was designed to protect the free flow of reliable information vetted through professional journalistic processes, not to shield self-styled online personalities whose content is indistinguishable from message board chatter. To invoke privilege, a person must demonstrate a genuine nexus to recognize news media and participation in the news process. This is critical. As the New Jersey Supreme Court cautioned, self-appointed journalists or entities with little track record who claim the privilege require more scrutiny, and individuals who merely broadcast their own thoughts on social media do not qualify. Allen is precisely that type of personality. He is not employed by any traditional news organization, nor does he engage in the processes that define journalism, fact-gathering, verification, or editorial oversight. His work consists primarily of posting opinions, commentary, and reactions to existing content, not factual reporting. And by his own admission, he has publicly proclaimed that he is not a journalist and instead only considers himself one when it suits him. He cannot sidestep these admissions to gain access to a privilege for which he does not qualify. Courts have long recognized the distinction between expressive commentary and news reporting. Allen's content, which solely consists of social media posts containing republished material and reaction videos, falls on the latter side of that distinction, resembling gossip or entertainment chatter rather than journalism. Okay, so they make note of too much media, Self-proclaimed journalists who claim to investigate and report on online adult entertainment industry could not invoke the Shield law for comments she made on an internet message board. In short, Allen's social media accounts are unfiltered, unscreened spaces for personal expression that lack any safeguards safeguards of accuracy or reliability. Extending the privilege to someone like him simply because he has a large social media following and purports to engage in journalism at times would eviscerate its limits and transform it into a blanket shield for entertainers and commentators, contrary to the statute's purpose. Now, the footnote, a glance at his Instagram or YouTube confirms as much. See King Akademiks, YouTube.com. They say, just look at this motherfucker's content and tell me if you believe he is a journalist. B. Allen cannot demonstrate the necessary purpose to gather or disseminate news. Allen also cannot demonstrate that his content is generated for the purpose of gathering or disseminating news. The Shield law does not extend to professionals paid to promote specific clients or products. Holding the Shield law did not protect witness where purpose is to manage the news rather than disseminate it. Quite unlike professional news people, Allen admitted to being paid by artists and record labels to promote songs, music videos, or albums or a particular artist more generally. And he's admitted to this numerous times on his own streams that he gets paid by labels. Accordingly, his purpose is not to gather and share the news. It is for entertainment or to promote viewpoints and artists based on who will pay him. That is far more akin to managing news rather than disseminating it. That will not do. So they say he is not a reliable source for information. He's paid for his viewpoints. Something that he contradicts himself and says, my opinion can't be bought. But yet he always talks about how the labels pay him to speak on artists. Allen did not obtain the underlying material in the course of professional news gathering activities. Allen cannot show that he obtained the underlying material in the course of professional news gathering activities. The Shield law defines receiving information in the course of pursuing his professional activities broadly to include any situation, including a social gathering, in which a reporter obtains information for the purpose of disseminating it to the public. Though typically a certification establishing those points will suffice, the New Jersey Supreme Court has urged that self-appointed journalists or entities with little track record who claim the privilege require more scrutiny. We've already read that part. It's being reiterated. Cautioning that the popularity of the internet has resulted in millions of bloggers who have no connection to traditional media. Any of them, as well as anyone with a Facebook account, could try to assert the privilege. Okay? Blogger claiming privilege met third factor only where she provided certification of the nature of why she obtained information. Allen cannot show entitlement to withhold his source. He has merely proclaimed that he had an exclusive and was going to tweet it any day. It didn't matter. But that does not meet his burden to establish his exclusive was obtained in the course of professional news gathering activities, nor could it. Allen confirmed that his content about the Peterson trial was colored by his preconceived opinion that Miss Pete was a liar and Peterson was innocent, and he was a fan of Peterson's before the two even met and had a pre-existing friendship with him. Now, as much as I would like to get through this expeditiously, I do want to put a pin in this and just speak candidly for a moment about what it is that we're reading in front of our faces here. They're pointing out that the DJ that don't spin already had preconceived notions and opinion as to what happened. He was given privileged information, quote unquote. I won't even say privileged. He was given documents that he should not have legally had access to. We'll just say that as to what it is, which further swayed his opinion, and he put it out there before it was even addressed in court. Not to mention him having a friendship with Peterson and perhaps being paid by Tory Lanez. Right? So all of this is going to create a trickle-down effect, even for people like myself, which is why I keep it a buck with y'all. I share my opinion, how I feel, And when I'm reading something that is legitimate, the documents, I do my best to read it, interpret it to the best of my knowledge, and then I tell you my opinion. I'm not here to disparage anybody. I can only give my opinion. I don't claim to be a journalist. I don't use that, you know, when it fits. I'm just a person that gives y'all the news. You know what I'm saying? And I give you my opinions. But this should let people know to be very careful about how to use your words when you jump into this. Okay? And that applies to me as well. Allen's purpose has never been to gather or disseminate news, but to broadcast his personal opinions and promote narratives. See, that's one thing I don't do. I don't promote narratives, right? I just share opinions. Promote narratives and artists depending on his personal and financial interests. I've never been paid by an artist to promote nothing. Only way that y'all would see that happen was if I were to do live music reviews and artists maybe had to pay to, you know what I mean, be at the top of the list or something like that, which I don't even have time to do. So there's that. You know, some people feel like, oh, you spoke about Cardi B's album favorably. She paid you, or because she retweeted your Imaginary Players video, now you're gonna just speak positively about her. Well, how positive is a 7 rating, which is a good rating, but come on now. If I felt like I needed to suck up to Cardi B, I could at least went to an 8 or above. Come on, man. I think it's weird. Anyway, let's get back to the matter at hand. That was no different during the Peterson trial. He should not now benefit from the Shield law's protections. Allen should be compelled to produce documents responsive to Ms. Pete's subpoena. Allen should also be compelled to produce documents responsive to Ms. Pete's subpoena because he has neither served objections nor offered any justification for his failure to comply, and the deadline to do so has long since passed. So he's just evading protocol, evading legal requests. A person commanded to produce documents pursuant to Rule 45 subpoena must serve written objections before the earlier of the time specified for compliance or 14 days after the subpoena is served. Allen did not serve any objections within that time, nor has he moved to quash or otherwise sought relief. And at least Aiden Ross had his legal team try to legally maneuver his way out of it, which was declined. So with Mr. No Spin not even taking the proper legal action, I don't see how he gets out of this. Having failed to timely object, Allen has waived any basis to withhold responsive documents. The failure to serve timely objections to a subpoena may constitute a waiver of any such objections. The court should order Allen to produce all documents responsive to Ms. Pete's subpoena without further delay. Conclusion. For the reasons set forth above, Ms. Pete respectfully requests that the court grant her motion and issue an order. 1. Directing Allen to produce documents responsive to the July 22nd, 2025 subpoena and sit for a court-supervised in-person redeposition, meaning you're going to have to leave that house, sir. You ain't going to be able to zoom. You're going to have to get your ass off your ass. And 2. Sanctioning Mr. Allen in the event of non-compliance in an amount not less than the actual costs incurred by Ms. Pete for bringing this motion and in connection with her efforts to secure his compliance with the subpoena. Sanctions, legal fees. Okay? Let us move forward. We now have declaration of Joanna Manillo, one of Megan's lawyers, in support of the motion to compel. And there is a list of exhibits that have been submitted, okay, to corroborate with what it is that they're speaking on. Um, let's see. Attached here to Exhibit A is true and correct copy of the second amended complaint that's coming from Megan. 3, attached here to Exhibit B is a true and correct copy of August 14th deposition and document subpoena served on Livingston Allen. Exhibit C is a true and correct copy of relevant excerpts from the transcript from the August 22nd deposition of Mr. Allen. Attached Exhibit D, copy of a screen grab from August 2nd posted online by Mr. Allen. Exhibit E is a true and correct copy of a screen grab of another post from the DJ that don't spin, demonstrating that he screen recorded his deposition. Attached here to Exhibit F, copy of February 23rd, 2022 online post by Mr. Allen showing that it corroborates with the same post same day by Milagro. Exhibit H, copy of the transcript from February 23rd, 2022 proceedings in People of California versus Daystar Peterson. Mr. Allen appeared for his August 22nd, 2025 deposition without counsel present and confirmed his willingness to proceed in the absence of counsel. During that deposition, he was asked to identify the source of information. We went through this, right? This is Megan's lawyer basically just reiterating that what's in this paperwork is real and true. Trying to save a little time here. So Exhibit A. Spit that Wonderama. All right. Pursuant to the court's February 7, 2025 order, plaintiff Megan P. hereby files the second amended complaint herein after the second amended complaint against Milagro Cooper. So this is Megan's second amended complaint lawsuit against Milagro. We're not rereading the lawsuit. That's what we're not finna do, all right? So just give me a moment. Matter of fact, let me skip ahead. All right, Exhibit B, featuring Yasin Bey. Megan P. versus Milagro Exhibit. I called her Exhibit. Where would have pimp my ride? Face ass. Milagro Elizabeth Cooper. This is a subpoena to testify at a deposition in civil action. This is the subpoena of Livingston Allen, a.k.a. the DJ that don't spin. It says testimony. You are commanded to appear at the time, date, and place set forth below to testify at a deposition to be taken in this civil action. If you are an organization, you must promptly confer in good faith with the party serving the subpoena about the following matters or those that set forth in an attachment, and you must designate one or more officers, directors, or managing agents, or designate other persons who consent to testify on your behalf about these matters. So these are just their records of subpoena to the DJ that don't spin, which he couldn't spin out of, but he tried his best to spin narratives while having the conversation. Okay, this is attachment A to subpoena Deuces Take'em to Livingston Allen. Pursuant to Federal Rule of Civil Procedure 45 and the accompanying subpoena, you are hereby requested to produce for inspection and copying the documents and communications identified below. So these are the things that he was requested to submit. Unless otherwise defined, all phrases and words herein shall be accorded to their usual meaning and shall be interpreted and in their common ordinary sense. So number one, call logs refers to records of information, phone calls made or received, including caller and receiver details, date and time, duration, and type of calls. Civil action refers to the litigation titled Megan Pete v. Milagro Elizabeth Cooper, pending before the United States District Court. 3, criminal action refers to the criminal case, People v. Daystar Peterson. 4, communication is used in its broadest ordinary sense. Blase bleezy, right? All of this includes email, picture, photograph, recordings, text, messages on any communicative or social media application, i.e. WhatsApp, iMessage, Slack, Facebook Messenger, Google Messages, Microsoft Teams, Zoom, Cisco, WebEx, Signal, Line, WeChat, Wicker, Snapchat, Telegram, face-to-face meetings, telephone conversations, or any other means of capturing information. Okay? going to skip past some of this stuff to get to what it is that we need. Social media post refers to any content published, shared, or broadcast by a user on any social media platform. Self-explanatory. Daystar Peterson and Mr. Peterson refers to Tory Lanez. Peterson Group shall refer to the following individuals, both collectively and individually, as in Sunstar Peterson, his dad, Caesar McDowell from Unite the People, Mitch McDowell, Carl Crawford from 1501, Danielle Frost, Todd Perry II, Trinity Jackson, Diana London, which is the lady who came in trying to get government assistance for Tory Lanez with his appeal, Anna Paulina Luna, Mary Ronquillo, any member of Daystar Peterson's counsel for the criminal trial or related appellate action, including but not limited to any member of Unite the People, George Megadesian, Sean Hawley, the lawyer that decided to drop him like a bad habit because he wouldn't listen to her legal advice. Also producer of Reasonable Doubt. And if you happen to watch Reasonable Doubt, I got a song placement on episode 2. It's a song that I wrote for a producer by the name of London Elixir. Played it on here before, get into the money. But go check it out. It's the YouTube compilation of Cash Doll saying broke ass boyfriend or something like that. Megan Pete and Miss Pete, and I don't know Sean Hawley, by the way, for anybody out here trying to play. Anyway, Megan Pete, Miss Pete, refer to the plaintiff, Blase Bleezy. Instructions, let's get to it. This subpoena applies to all documents in your possession, custody, or control, regardless of their location and irrespective of whether such documents are held by your officers, employees, attorneys, accountants, consultants, representatives, agents, or any other person. You are requested to make a diligent search of your records and other papers and materials in your possession to the extent necessary to provide responsive documents. Unless otherwise indicated, the subpoena seeks all documents that were created or received by you at any time between July 12, 2020 through the present. So from the time Megan Thee Stallion was shot up to today, any communications you have with the aforementioned Tory Lanez, his legal counsel, his family, please bring it to the front. This subpoena contains continuing requests. Should you become aware of or acquire possession, custody, or control of additional responsive documents, you shall promptly produce these additional documents for inspection and copying. The subpoena seeks production of each document in its entirety without abbreviation or redaction, including, without limitation, all attachments, transmittal sheets, notes, cover letters, exhibits, enclosures, and all drafts and non-identical copies of each document. If you object to any portion of any request identifying the portion to which you object, answer the remainder and produce all documents in parts. If you object to any request as overly broad or unduly burdensome, produce those documents which are unobjectionable and specifically identify why you believe any request is overly broad or unduly burdensome. If you do not possess any documents responsive to a particular request, say so, nigga. It says so, state. That's what they telling you to say. If production of any document is withheld on a basis of a claim of privilege, which they've already denounced, each withheld document shall be separately identified in a privileged document list. The privileged document list must identify each document separately, specifying for each document at least 1, the date the information was created or communicated, 2, authors, senders, or recipients, and 4, the general subject matter contained in the document. The senders and recipients shall be identified by position and entity, corporation, firm, partnership, etc., with which they are employed or associated. If the sender or recipient is an attorney, they shall so be identified. The type of privilege claim must also be stated together with a certification that all elements of the claim privilege have been met and have not been waived with respect to each document. Okay? Each document shall be produced in its entirety, including all attachments and disclosures. Don't be trying to mix and match like you do your outfits. A document with handwritten, typewritten, or other recorded notes, editing marks, etc. is a separate, unique document and is not and shall not be deemed to be identical to one without such additions, deletions, or modifications. We want the OGs, not the remakes. Okay? We're not doing no reissues like Jordans. any portion of a document is responsive to a request, produce the entire document, including all attachments, enclosures, posted type notes, and any other matter physically attached to the document. If a responsive document cannot be produced in full, it shall be produced to the extent possible with an explanation stating why the production of the remainder is not possible. So if you don't have the OG, you better say so, for you have to report to the OGs. All documents produced in response to the subpoena shall be produced in the same order as they are maintained in the ordinary course of business, and where attached shall not be separated or disassembled. Each request shall be construed independently, and no request shall be viewed as limiting the scope of any other requests. Whenever necessary to bring documents within the scope of these document requests that might be otherwise be construed to be outside of their scope, the use of a verb in any tense shall be construed as the use of that verb in all of the tenses. All right, some of this shit we're going to skip. Documents requested. All documents and communications between you and defendant that refer or relate to Ms. Pete, the civil action or the criminal action. And of course, defendant is Milagro. So all communications between yourself and Milagro Grrrls that have to do with anything regarding Ms. Pete, the civil action, which is the lawsuit from Megan to Milagro, or the criminal action of Daystar Peterson being prosecuted by the state of California. All documents and communications between yourself and Daystar Peterson, aka Tory Lanez, or any member of the Peterson group, father, baby mama, Unite the People, Deanna London, Linda Luna, or etc. All documents and communications that refer or relate to any payments or items of value from you to defendant. Remember, the DJ that don't spend made a public statement that he would literally pay for Milagro's legal fees, which he didn't act on. She shitted on him publicly because he didn't when the water got hot. But he made a public declaration that he would, and for any other bloggers or content creators that happen to be legally pursued by Megan Thee Stallion. But again, once the jacuzzi began to heat up, he went back home. All documents and communication that refer or relate to any payments or items of value from Daystar Peterson or any member of the Peterson group to defendant. All documents and communications between you and defendant that constitute, memorialize, or refer to any interactions between defendant and Daystar Peterson or any member of the Peterson group. All documents and communications that refer to or relate to defendant's social media posts about Pete. All call logs between you and defendant. Have you and Miss Milagro ever spoken on the phone? We want to know. When was it? What was it about? What's happening? Exhibit C, oh Lord, it's me. Deposition transcript, Megan Pete v. Milagro, Elizabeth Cooper, Livingston Allen, contains confidential portions. Sorry, y'all, I gotta entertain myself along the way at some point. This shit long as fuck. So here we're getting into the transcript of Mr. No Spin's deposition, all right? So this isn't just piecemeal together for what he wanted to share on social media. These are the official. L. Allen, protective order defendant in that case. Answer, yes. Okay, so even though you've been deposed before, there are a couple of things I want to go over with you. The first thing I want to go over with you is that I noticed that it doesn't appear to me that there's an attorney here representing you today. Do I have that right? He says, yeah, chilling. Okay, do you have an attorney that typically represents you in matters like this? He says, yeah. Okay, and so you're aware that you're proceeding today without an attorney present? He says, absolutely. Okay, are you comfortable with proceeding in that fashion? He says, of course. Did you talk to any attorney that typically would represent you about today's deposition? He says no. So he confirmed that he does have a lawyer that he would generally consult with for these sorts of matters. But for this deposition, he decided not to reach out at all. Okay. So, just so the record is clear, the witness has confirmed that while he doesn't have counsel present today, he is comfortable proceeding in the absence of counsel. So, as I mentioned a moment ago, Mr. Allen, there are a couple things that I like to go over, even though you've been deposed before, just to make sure you and I are on the same page. Is that all right? He says, sure, go ahead. Okay. So the very first thing is that the most important person in my view in this sort of virtual proceeding is the court reporter. And the reason why, as you probably could imagine, is that she has to take down every word that I say, that you say. If Miss Dixon says anything, she has to make sure that all of that is accounted for. He says, I always tell the truth, but yes. Boy, get the fuck out of here. Okay. And you understand that the oath that you took just a moment ago is the same type of oath you would take if you were testifying before a judge or a jury in court of law, right? He says, absolutely. Which is to say that it's testimony under the penalty of perjury, which means if you lie, there are consequences for that. Do you understand? He says, yes. Okay. Now, it appears to me that you may be in your recording studio. I just have a couple of questions about that. Are you in the room alone? He says, yeah. Okay. Do you have a phone or any other device in which you can communicate in front of you? He says, we're on a computer, so I have multiple monitors. So I guess technically, yes. Okay. So let me break that out a little bit just to I make sure I ask all the questions I need to about that. Do you happen to have your phone in front of you? He says, my cell phone? Yes. He says, no. Okay. On your computer, other than this Zoom platform, do you have anything else up in front of you on any one of your multiple monitors that has sort of a messaging function open at this moment? He says, not at all, no. Okay, and can I ask you for the duration of this deposition that you not open or communicate with anybody outside of who's here? He says there's nobody to talk to, but yeah, sure. Is anybody that you know that's not listed in this participants list joining this meeting or listening in by any other means? He says currently, yes. He answers no. Okay. Have you set up any sort of recording device to record this deposition? He says, well, everything in my house is recorded. So that should be clear. There's 2 cameras back there for surveillance purposes. There is a running camera there all the time, but otherwise, yeah, no. Okay. So they explicitly asked him if he was recording this deposition. He says, nah, I just got 2 surveillance cameras back there. They always running. She says, okay, and the cameras that are present in your immediate vicinity, are they capable of capturing audio and video? He says, absolutely. Okay. Do you have any intention or plans to release a recording of this deposition to the public after it's concluded? He says, I plan on speaking about it, and most likely if I feel the need to, based on how this goes, unless there is a law against it, I would definitely use whatever other than the folks that you just mentioned. Did you talk to what? I would definitely use whatever. So he say he wasn't recording, but somehow he's going to use it if need be. Other than the folks that you just mentioned, did you talk to anybody else about the fact that you were being deposed today? He says, family. I mentioned on a few interviews, Aiden Ross. I said, well, I didn't tell him I was being deposed. I said, you guys subpoenaed me. Well, at least at first. And then we missed that date or whatever. So we see there is background communications going between himself and Aiden Ross, which we knew because it was announced on social media. But just to paint the picture here of background communication. Right. And that was posted online, that conversation. Yes. Did you talk to outside of the context of what was posted online? Did you talk to Mr. Ross about the subpoena? He said, yeah, he called me saying that you guys tried to, I believe, show up to his house and harassing him. And I told him, I said, hey, typical Rock Nation tactics. They say, do you believe that serving legal process of a subpoena is harassing? He says, no, because that's within the context and the confines of what happens in a civil case. However, just grabbing random people that have zero association, and I've read through this case with the allegations being made with zero basis, just the fact that you could legally twist the arm of people to get people to come in and sit for a possible 7-hour defamation. You called it a defamation thing? Freudian slip. Or not defamation, a deposition here, testimony. Yeah, that's definitely harassment. He says, you don't think that these guys have time. Like, I think my time is valuable just like yours, except you're doing your job. I'm lending my time to the justice or the judicial service, I guess. But if I have zero association with the things being alleged, just like Mr. Ross has zero association with the things being alleged, yeah, you're wasting not only the court's time, but you're harassing people who may be even remotely in a 10-foot or 1,000-foot proximity of not only the defendant, Ms. Cooper, but definitely a third party that's not mentioned in a co-defendant or plaintiff's, capacity, Mr. Lanes. So yeah, I think it's harassing. Yeah, there's no other way to think about it. So although you've allegedly received privileged information, as you've tried to say, when it's really information that was sealed by the courts, you think everything is just regular, just cool? They say, do you understand that as part of a civil lawsuit, attorneys are allowed to serve third-party subpoenas on individuals that they think may have discoverable information related to the case in one way, shape, or form? Yes, I understand that, but also, okay, do you know the basis for why Ms. Pete is seeking the deposition of Mr. Ross? He says no. Okay, so you don't actually know whether or not there's zero basis or adequate basis or sufficient basis or more than that to seek the deposition of Mr. Ross, right? He says, well, speaking with him, and I've been the liaison to, connect them, whatever it was, a stream or whatever before. He had limited conversations or even association with Mr. Lanes and doesn't know who the defendant is and has never spoken with the plaintiff. I find that to be very interesting because Mr. Aiden Ross went on a whole stream filled with Happy Dad advertising and had nothing but terrible things to say about Megan, gleaming things to say about Tory Lanez. And then the host had a call with Mr. Lanes talking about the conversation. And you talk to Tory Lanez, and he talks to Tory Lanez. Milagro used to talk to Tory Lanez. You all are media personalities that disseminate information, and you happen to echo and parrot information allegedly sent to you by Tory Lanez. But you think that you're talking around the situation. So it's kind of like, all right, I guess it's the equivalent of what you're saying. It's like saying, do you know that the police could pull you over because you're driving on the road? Nah, nigga. But if they pull you over every block, is it harassment or do they have the right to? So you're right. You have the right, but blank. Mr. Allen, I don't. You have the right. I don't think I'm saying anything. I'm just asking you questions. So you're free to answer my question in the manner that you deem fit. But it was just a simple question of whether or not you knew what was in Miss Pete's head when she was serving subpoenas on individuals, and I take it that you do not, right? That was a great one. He says, I don't read minds. You're right. Okay. And Mr. Ross told you that he believed that Miss Pete was trying to serve a subpoena for his deposition on him, just like we served a subpoena on you, right? He says, well, he was just instructed by his security people that there was an attempt. Okay. When they asked him what it was about, they mentioned Quinn Emanuel, the firm you work at. And this was right after I told him on a live stream that I got subpoenaed. He said, do you know what that's about? And I think they mentioned Miss Cooper, but he had zero idea who she, So you saying Aiden didn't know who Milagro was? One of my headquarters, but I don't know if they're actually still there. I don't know what's going on with some of these pages. But I do have them immediately here. No. Okay. So would you consider yourself to be a streamer? He says, I consider myself to be a streamer, a blogger, a media personality, broadcaster, media company owner, everything. So that would be fair. And that's how you make your living, right? He says, yeah. How long have you been doing that? About 15 years. And I know that your sort of public name is DJ Akademiks. Were you at one time a DJ? You don't spend no more. Yes. Do you still do that at any point in time? He says, rarely, but at times. Lying motherfucker. How did you decide to get into that realm? I'm just going to call it streaming so that we don't have to go through all the delineations of what it could be confirmed, if that's okay with you. Okay. So how did you decide to get into that line of work? He says it was a natural progression. Started out DJing around 2009. That became me. First of all, it's not obvious by the well. I guess the court reporter can't type a physical thing. It was a Jamaican flag back. I'm Jamaican. So anyway, in Jamaican culture, the DJ is also usually the voice of the culture. So when I started DJing back in college, I got on the college radio. I felt that it needed to be like a necessary like part of my career. That turned into me wanting to get on radio. Eventually I stopped DJing as much as I started putting out videos online, kind of developing a platform, and I started streaming around 2013, 2014. That was a way of me trying to find my core group of supporters and followers, and then eventually that turned into the lay of the land, so to speak, in the sense of the business structure of how people were now consuming content to turn to streaming. So there became a lot more people checking out streams. Miss Harris, we couldn't hear that question, Your Honor. What type of content do you typically stream about? Music, urban topics, hip hop specifically, music industry stuff that kind of encompasses everything. Do you consider yourself to be an influencer? He says, I guess technically by the word, sure, yes. So would you agree with me that your posts on your content can have an impact publicly? He says, yes. And it can impact public perception. He says, yes. And you can influence conversations online. Yes. Change minds of the public. He says, not necessarily change minds, but influence. And you can persuade people, right? He says, yes, but it's, Ms. Dixon says, objection as to form. You can answer. Still, I believe it's up to the person to change their mind given the information, but could that information be influential? Yes. However, being able to change someone's minds, I wish I would be able to do that. I got a couple minds that I want to change. Information. I hate that some of this shit is skipping around. Anyway, Rock Nation. Go ahead. Why don't you give me the list and then we'll go through it? He says, well, we're not going to sit here and name labels for years. Rock Nation, a lot of UMG associated record labels, a lot of Sony associated record labels, but I mean, there's hundreds under both companies. So Sony has hundreds, UMG has hundreds, and of course, Warner, there's hundreds as well. Okay, any entertainer specifically, in addition to like a record label, has any entertainer or artist ever paid you to post specific content? He says, I'm going to say no in the context of even if an artist, let's say, I don't know, say there was an artist that paid me that wasn't under one of those record labels. I'm telling you, I chalk it up as a record label because they're paying me for music. So primarily the payment. Okay, so they're getting into the nature of who has paid him to speak about their music or other things on his platform. So primarily the payments have been all to do with, hey, I want to promote a song. I want to promote my music video. I want to promote my album. That's pretty much what it is. We don't take payments for don't talk about my arrest. Don't talk about me beating my baby mama. Don't talk about me lying about sleeping with this guy or this girl. We don't do that. So he claims he does not take payments to sway opinion about news stories, but he will take payments to promote music that he otherwise wouldn't cover. Who are some of the artists that have paid you that even though you chalk them to up and coming from the record label, who are some of the artists that have said, hey, I want you to promote my music? He says, well, so now I guess we're talking about independent artists because usually everything with labels, there's usually a funnel to deal with that. Like, okay, let me see. You're looking for examples? He says, yeah. He says, okay. Excuse me. I mean, now I feel you're a little hyperbolic there. I understand. Is that what you're referring to when you said earlier, like every, record label, under the sun hyperbolically has sort of paid you in one way, shape, or form to promote a particular artist of theirs? Is that what you meant when you said online that you've pimped the entire music industry? He says, oh, absolutely. Okay. And I think in that same post you said, I could tell you 10 artists that tried to pay me. Do you remember saying that? He says, finish your question or finish the statement. Yeah, you said, I could tell you 10 artists that tried to pay me when you were talking about the various ways that you've pimped the music industry. Damn, what the fuck? Streaming, have our content be visible. That's it, while live streaming. Now, if that content is repurposed or say there's a random clip of someone falling off a bike, I don't like how this shit is laying out, man. These pieces are not complete. Clip of someone falling off a bike that gets posted with a Stake logo. I don't have any contractual or working relationship with Stake that actually deals with that. Okay. Do you still maintain the relationship with Stake as you've described having it in the past? He says, yes, I still have a decent relationship with them. Yes. Okay. So you still, as you're streaming, will have their logo display or on view. He says at times, yes. Okay. When did you first meet Tory Lanez? First met Tory Lanez is kind of such a long time ago, kind of almost want to say like 2000, and it might have been like crap. How long I've been doing this? Like maybe 18, 19. So he says 2018, 2019 when he met Tory. Did you know who he was before you met him? He says, yes, he was a wildly successful music star, someone who I enjoyed his music a lot, and someone who was very ambitious in trying to get the eyes, ears, and attention of not only fans, but even challenge some of the top rappers, including my favorite top rapper, which was Drake. Were you a fan of Tory Lanez's music before you met him? Yeah, of course. When you first had occasion to meet him, was that a result of him reaching out to you or somebody on his team reaching out to you or you reaching out to his team? He says they invited me to, I believe, a show, and I believe that's the first time I met him. I think it was a show, and the show was at like SOB's. SOB's a nightclub, or used to be. I don't know what it is now. It's a particular venue in New York City. Did you get to meet him? Relationship developed because you were able to hit it off so well. Is that about a fair approximation of what you were saying before? Yes. So you guys had occasion to go to dinner. He says never went to dinner. Okay. Well, did you have occasion to hang out with one another outside of any sort of professional context? He says, yeah, I've gone to the club with him. I've been to his penthouse in Miami. Would you say that I'm sorry, go ahead. He said, I was just going to say, would you say that you have a close personal relationship with him? He says, well, it depends on what we're talking about. So I would say I know him more than most rappers. I wouldn't say that we're best friends. Like, I'm pretty sure I'm on the list of people that he would call if he had a problem or issue or needed someone to talk to. Find that to be very interesting. You're on the list of people that Tory Lanez might call if he had a problem, issue, or needed someone to talk to, a confidant of sorts. He says, unless it was music in nature, he's probably not calling my phone. You sure about that? The last 5 years? So it was one of those people where, like, how you have work friends and then you have that one friend that you might invite out to the club, but you won't go everywhere with them. So it's like he's like a work associate that is a little bit closer than others because we have hung out in other capacities. But I would say I'm one of his closest and bestest friends? Absolutely not. Would I say he's the same to me? Absolutely not. But would you consider him a friend nevertheless, even if not a close friend? He says, yeah, of course. Another skip. Was a lot of doubt that I thought was more than reasonable. So under that premise, I don't see or I couldn't stand behind a decision to put somebody in jail for 10 years when there is more than what I believe is reasonable doubt that he didn't commit these crimes. So, from there, I'm not going to agree with any type of incarceration of him. So this is him explaining his reason as to, I guess, why he won't speak against Tory Lanez in terms of him being jailed. Did you reserve your opinion with respect to whether or not you thought that there was sufficient evidence to sustain a conviction against him until after the trial concluded, or did you speak on it during the duration of the trial? He says, oh, definitely spoke on it during the duration. When people watching me give an opinion or cover a trial, it's definitely rooted in how I see it mixed with, hey, listen, these are the facts. But as we all know, a lot of times facts could, depending on how you put them, in what order, and who the facts supposedly are coming from, or even the testimony, it could really, the person who's receiving those things could go either way. So I always have an opinion and point of view. So from the get-go, I definitely thought, hey, listen, this is a crock of BS. And yes, that means bullshit. From the get-go, where the victim was supposedly, I feel like she was just lying. I felt like she was a habitual liar. I felt like she couldn't tell the truth to save her life, he says. And then now, when it relied on her testimony along with a couple other things from what I had seen, but her testimony definitely wasn't important. They say just to interject real quick. When you say a couple other things, you mean other evidence that was admitted at trial and considered by the jury during the criminal trial, right? He says yes. Here we go with another skip. Publicly posted on Instagram that Kelsey did not shoot Miss Pete. Tory posted that, he said. She says, I'm asking if you're aware. So they're asking him, did you know that Tory Lanez publicly posted on Instagram that Kelsey did not shoot Miss Pete? That's what he said. So when people say, it was Kelsey, remember, this man came out and said, no, it was not. So either it was him or it was his driver. Megan says it was him. He was the one apologizing. We shall continue. He says, I know his account posted it. Is it Tory? He says, are you aware of somebody else running Mr. Lane's account on his behalf? He says, I'd be surprised if Tory runs his account even a quarter of the time. Tory Lanez, like many other artists, when I communicate with them, especially via, like, say, DMs or something like that, it could be any host of people. So he's saying, I don't know if that was Tory himself that posted that, but why would somebody running his account speak to the nature of who shot the gun and absolve somebody of their involvement when he is being put under investigation? He basically said, no, she's innocent. Which then points to, okay, so it must be you, motherfucker. He says, I'm still talking to a deceased person, King Von. His Instagram messages me all the time because his manager runs that account. Do you believe? He says, I don't know who's running it. Do you believe, Mr. Allen, that somebody who's managing or running Tory Lanez's account for him posted that's not true when another person posted online that Kelsey was the shooter? Objection as to form. He says, so I actually believe it's one of two things, right? I believe it wasn't. That's not Tory on the account. Wow. Or I think this is more the reasonable belief. I think to keep it real, Kelsey did it, and Tory been trying to protect Kelsey. So let's put a pin in this. He says he believes Kelsey did the shooting, and Tory's just protecting her. So if you're protecting Kelsey and saying she didn't do it, you're the next man up. You should be willingly taking the charges. If you're protecting Kelsey, you would say, she didn't do it, I did it. And you wouldn't be trying to do all this bullshit to say you didn't do it, because you would have taken the charges, taken the rap to Kelsey's benefit. He has contradicted that every step of the way. So no, I will not accept that personally. He says, I don't know why he won't tell who shot her. I would have been told on her. That's the facts. You know what I mean? Like, I would have been told. But I think Tory's not a gang member. He's a guy who's like kind of a quasi street. And I think he's always been like, hey, I got to not be as forthcoming with this information. And trust me, I listened to all the interviews he had with the police because I wanted to hear them. Like, usually when people get in trouble and feed it to the fire, you just say it. And he was always this vague, and I get it. He's a guy who believes we don't speak about certain things that could be criminal in nature, whatever. And if you ask me based on, again, remember, you're asking my opinion here. I think if Tory was shooting Meg be dead. What? He ain't a gang member. He's a quasi street nigga. But you think if Tory were to be doing the shooting, he would have unalived her. What? What would give you that indication? He says, we're talking about somebody who's alive and twerking. I think she'd be dead. I think what happened is she was fighting with her friend over the fact that they were in a triangular relationship. Boy, oh boy. Somehow the gun got into play. If Tory's trying to shoot her, I believe she'd be dead. He's not missing 5 shots, I believe. So I believe what that indicates to me, Mr. Allen. Also, Mr. Allen, say again, how badly do you believe that wait, you just came out and just said this girl did the shooting? Hey, what's most rappers, they say, so Mr. Allen, just so that I got it straight, you believe this man is doing a 10-year bid for Kelsey when she's the one who shot Megan Thee Stallion? Come on. He says, ma'am, there's a lot of people in black culture that do that. He comes and emanates from that type of place. Yes. I think he's stupid. Trust me, I think it's stupid. Typically, people that take the rap for somebody's somebody's crime is submitting themselves, not fighting it. The lies ain't adding up. So not only do you think he's stupid, but you think who you're talking to is. He says, you know what I mean? Like him and Kelsey should have bunk beds if it was going to be that. But I do believe that in reality, he was not as forthcoming. He was not helpful at all in the investigation. And once the investigation targeted him, he thought he was protecting her because he's like, hey, no way they're going to be able to say I did it, dummy. And then it was able to be at least proven, at least according to the jury, that's where he is. That's why he is where he is. Did he ever tell you that's what happened? He said he never told me. That's the thing. He refused to tell me anything that was in. They say, okay, did anybody who was actually present on the night in question when Miss Pete got shot actually tell you that that's the story? He says no. But just like most people online, we have to use our own common sense. We have no video. Right. What you do is you sit and you speculate, right? He says yes, and that, so they say, so everything you just said was a whole lot of speculation, right? Absolutely. Okay. Because you have no basis in any admissible form to support anything that you just said, right? No, based on some of the context and observations that other people made that was given to me. So yes, I felt it was an odd trial, something that we needed eyes and ears on the ground. And then there were eyes and ears on the ground, weren't there, whoever the spectators were that were already in the courtroom. Yeah, and even, they say, and as we know, Miss Cooper was there every day, and she was reporting on what she was hearing at the trial. He says, amazing set of eyes and ears. Are you aware that she was taking notes every single day during the trial? He says, she told me that every time we got online. Do you remember earlier this morning, Mr. Allen, I asked whether or not you had any phone in front of you or any application open on your computer that would facilitate any sort of messaging? He says, yes. And I asked you to try and refrain from that during the course of the deposition. Yes. Okay. Do you believe that posting on social media is a form of messaging? He says, not messaging an individual. They say, okay, stupid motherfucker. Miss Manillo, Atlanta, can we mark at Exhibit 129, tab 101? Miss Harris, yes. Okay, so they say here, Plaintiff's Exhibit 129, DJ that don't spin posted. Trial starts today. DJ Blank does a deep dive on the Megan Tory case, goes through the timeline. Not bait stamp, marked for identification as of this date. Plaintiff's Exhibit 130, Akademiks TV Twitter post, not bait stamp, marked for identification. Do you recognize Exhibit 130, Mr. Allen? He says, I do. This is a tweet that you sent today. He says, I didn't send that tweet. They say, well, I am Akademiks, the original tweet. That's your Instagram account, right? He says, it's not a tweet. Okay, so you posted on your Instagram account during the course of this deposition. He says, yes, definitely during the break, yes. They say, okay, which break was that? He says, one of the breaks for lunch or one of the times. They say, okay, and you wrote, this deposition Meg Thee Stallion got me in asking about Tory, Drake, and Nicki Minaj more than their client Meg Thee Stallion. So they're addressing him head on about him posting about his deposition while happening or while on break, as he says. And I think that's 3 laughing, crying emoji faces, right? He says, yes, yes, indeed. Okay. And then you quote as if you're saying something I said, right? He says, well, I didn't attribute it to you, but I did put things in quotation. Right. But you put it in quotations to suggest as if these are the questions you're being asked, right? He says, I didn't. You're putting words in my mouth at that point. Okay. So then why don't you tell me what the purpose of you putting quotes in your Instagram account around these phrases was? He says, because I wanted people to understand the subject matter I was being questioned on. Is Drake paying you? Is Nicki paying blogs? Who is this Grand Wizard guy? And is Tory sending you money on Cash App? Actually, I meant to put a couple of more things. I don't know what you. So just so I get that clear, we had a whole conversation this morning about how there are aspects of this deposition that may be kept confidential, and you couldn't even wait until the deposition was over before you started posting about it on social media. He says, well, I mean, y'all even invite me to they say it's a yes or no question. He says, oh, sure, yeah. Okay. And so what you wrote here was, you sure Drake ain't pay you, right? That's the first thing. He says, can I use my phone on a break? They say you're allowed to use your phone on a break. There's nothing prohibiting it, but since you did it, I'm going to ask you about it. So you wrote, you sure Drake ain't pay you, right? He says that was a hilarious question. Or, what is this? I hate how this shit is bouncing around. A DNA report? I didn't get a DNA report. So I didn't ask you whether you got a DNA report. I asked whether you got information about a DNA report before it was publicly available. So now they're getting to the so-called DNA report that Milagro and himself had been talking about online before Megan and Tory even went into the courtroom. He says, I did. Okay. And you know that because you received that information early, that the Los Angeles Police Department at a point in time conducted a DNA analysis on the weapon that was used to shoot Megan Thee Stallion, right? Yeah. And you understand that information was shared among the attorneys and the parties to the criminal trial, right? Yes. And like you and I have talked about this morning, in that case, that information was subject to a protective order, right? Yeah. Which means it wasn't supposed to be released publicly at the time, right? Yes. But you received that information before it was supposed to be released publicly, right? He says, I absolutely did. And in other words, while it was still subject to the protective order, right? Yes. And under the protective order, the only parties who had access to it was Tory, his attorneys, and the prosecutors, right? He says, you're telling me I wouldn't know. She says, well, you followed the story after you wrote about it, right? Yeah, but I'm not sure everybody who would be privy to know details or every detail or detail in that protective order of that particular piece of discoverable evidence. They say you were certainly not supposed to be privy to it at that point in time, right? He says that's a fair assumption. It's a fair statement, not an assumption, right? He says, well, I'll just assume because I never seen the protective order. Okay. You knew at the point in time that you received the DNA. Did you know at the point in time that you received the information about the DNA report that you weren't supposed to have it? He says, I didn't know at the time, no. Let's mark as the next exhibit, tab 19. I think it's exhibit at 131. And while that is being marked, I'll ask you a question, Mr. Allen. On February 23rd, 2022, you and Miss, Cooper both took to social media to talk about the DNA report. Do you recall that? He says, I don't know what she did on that day. I did go to social media at a point. I don't know what particular day. Okay, so let's pull up exhibit 131. They pull up Akademiks TV. This is the Akademiks is your Twitter account, right? It is. And this is one of the ones that we spoke about this morning that you said you operate, right? He says, I remember writing that tweet like it was yesterday. Okay. And for the sake of the record, this tweet is dated February 23rd, 2022, and you posted it at 11:43 a.m., right? Yep. And based on your comment a moment ago, I have to ask this odd question, but you do recognize this tweet, right? He says yes. And you did, in fact, send this tweet, correct? He says yes. And the tweet reads, breaking, in all caps. It was revealed in court a few moments ago that Tory Lanez DNA was not found on the weapon in the Meg Thee Stallion case, right? He says, yeah. I'm sorry, did you say yes? Yes. You later deleted this tweet, correct? He says, yes. Why did you delete it? Because everyone on social media turned to investigators and they were opposite of accurate. Cool, sure. So that's a yes to my question. It was false, right? Sure. Okay, let's mark as exhibit 132, tab 41. We have Milagro's tweet from the same date. Have you seen this tweet before, Mr. Allen? He says, never. Okay, I'll represent to you that it's a tweet from Miss Cooper on February 23rd, 2022, which is the same day that you sent the tweet that we just looked at, right? Sure. Well, you saw that Exhibit 131 had a date of February 23rd, 2022, correct? He says, I didn't look at the date, but yeah, I'll take your word for it, sure. Okay. And you see that she wrote breaking in all caps. It was revealed in court a few moments ago that Tory Lanez DNA was not found on the weapon in the Meg Thee Stallion case. Do you see that? He says yes. And that's the exact same language from your tweet on the same day, isn't it? He says it seems to be. And just for the record, this was a tweet that was sent out at 11:48 a.m., right? He says, do you know what time mine was sent out? 11:43 a.m. So just 5 minutes apart. He says it sounds right. Okay, so it appears that Miss Cooper copied your tweet and sent it out herself, right? He says yes. All right. He says yes. Count, I wouldn't know the times. Why don't we zoom in a little bit? For the record, Mr. Allen, I'm showing you Exhibit 134. This is a portion of the transcript from a hearing that was held on February 23rd, 2022. Do you see the document in front of you? He says, yep. Excuse me. And this was a hearing that was held in court on Mr. Lane's criminal trial. Can you tell from the top of the page? Yes. Okay. And you can see that this is the same day that you tweeted information about the DNA report, right? Yes. And it's also the same day that, as we just saw, Ms. Cooper tweeted information about the DNA report, right? Yes. And it's the individual, as you can tell from the top, who's speaking here is Sean Holly. Do you see that? Yes. And as we discussed earlier, you understand that Sean Holly was one of Mr. Lane's criminal defense attorneys in the criminal trial, right? Yes. Okay. And have you seen this transcript before? No. Have you heard about what happened during this court appearance before? He says, I heard, I did. And you can see here, she says, I can say to you that in my reading of what? Fuck, man. The hell is this? What? DJ that don't spin again, I don't know who that is. I don't know that any of our jurors will know who that is or really what he has tweeted. Okay, so she's making reference to his tweet in court. Got you. She says she don't know who he was. Do you see that? He says, I definitely do. Can you tell from the context of her statements that you sent the tweet before this hearing occurred? He says she's indeed referring to that tweet. Yes. Ooh. So how could you reveal something before it was even revealed in court? And to answer my question, it was that the tweet was sent before the hearing occurred, right? Most likely. Okay. And she says, I didn't even know the medium in which he operates, but what he said isn't correct. Tory Lanez legal counsel at the time said that you were reporting incorrectly. Do you see that? He says, I do see it. And just to be clear, we're talking about Tory Lanez attorneys in the criminal case saying that the tweet that, okay, but you can take away from this, at least she is suggesting and telling a court, and she is representing to the court that what you tweeted about the DNA report is incorrect, right? He says, yeah, it seems to be that, to be the case, yes. Do you have any reason to believe that what she was telling a court as an officer of the court, which is what lawyers are, was false? He says, yes, I do. I mean, Tory said that, do you have any reason to believe that your interpretation as somebody who is not a lawyer, not a forensic scientist, has no experience with litigation, has superior knowledge of how to interpret DNA evidence than a criminal defense attorney? He says, yeah, she's not an expert either. Of course. Wow. Tory said this same lawyer was, damn it, man. Why is this shit all cut the fuck up? But we know Tory believes that Sean Holly was paid off by Roc Nation. We'll pull up the recording. Plaintiff's Exhibit 135, video clip marked for identification. Plaintiff Exhibit 136, document titled 220234. Oh, Truth. Shout out to Opinionated Truths. Capture of Milagro Graham station head, not bait stamped. And for the record, This is a live stream from Miss Cooper on February 23rd, 2022. When even though this was publicly posted, this version of it, Mr. Allen, was exchanged between the parties and is subject to the protective order. Mr. Allen, do you recognize that? In that clip, Mr. Allen, you heard Miss Cooper speaking about you, right? Yes. And the tweet that you sent out about the DNA report, correct? Is that a yes? I'm sorry, I didn't hear you. He says yes. Okay. And she said that she believed that you had put it out prematurely, right? Yes. And that's because it wasn't supposed to be public at the time. So even Milagro, in her live stream on the very same day, said that you put the information out prematurely. He says, I had no idea why she's saying that, but y'all had communications behind the scenes. Okay, you can press play. You hear towards the end of that video, Mr. Allen, Ms. Cooper is saying that you and she had the same sources of information. He says, I heard. And did you hear her say that you were given the information and you spoke on it too soon? He said, I heard. And did you understand that to mean that she believed, as she said earlier, that you had prematurely shared information about the DNA report? He says, that sounds fair. Okay. Do you and Miss Cooper share the same sources as it relates to Tory Lanez? He says, I wouldn't know. So you don't believe that you and Miss Cooper have the same sources of information? He says, no, I don't think she had a source. So he believes that Milagro lying, or at least that's what he's saying now. He says, I think, hey, listen, I had an exclusive. I was going to tweet it at any day. It didn't matter. Also, it had nothing to do with Miss Megan Pete. I don't know why she blank. When did this exclusive come and who did the exclusive come from? He says that's something I would never reveal. So they say, well, what's your basis for not revealing it? He says, yeah, the very nature of me being a journalist. Here he is contradicting himself. Never once claimed he was a journalist. Now he's a journalist. I have sources that, again, unless y'all get me under a court order, which is why we're here talking about this today, because they're requesting a court order. They say, you consider yourself to be a journalist? He said, at times. Did you ever go to school for journalism? No. When you post information about current events, do you do so objectively? He says, it depends. What do you mean it depends? Do you report on things? He says, we do editorialize. They say, objectively. Do you ever report on things with a particular slant? He says, we do editorialize. Yes, absolutely. Okay. And you certainly editorialized about the Tory Lanez case, right? He says, my opinion is definitely known. In fact, everything you've said about the Tory Lanez case is just your opinion, right? He says, not true. There's some things that are clearly facts. Like if we said he got convicted, that's not my opinion. If we said that, hey, according to what the government ran tests on, that Tory's DNA was found inconclusive, that's not my opinion. So when you try to chalk it up as everything, I'll just answer simply by saying no. Did you ever take any journalism ethics classes? No. Any ethics courses on journalism? No. Any certifications related to ethics in journalism? No. Have you ever been hired by any news outlet? No. Any journalistic publication? No. And you're not associated with any journalistic publication, right? He says, no, I own my own company and we operate as an independent news outlet for hip hop. Have you ever said publicly that you did not consider yourself to be a journalist? He says, oh, definitely as well. So here he is once again confirming that he also states he's not a journalist. Okay, so when it suits you, you say you don't consider yourself to be a journalist, and when it does, you do consider yourself to be a journalist. Sure. Okay, so are you or are you not a journalist? Depending on what's being posed and what time it is. Hell no, Ning. Okay, so then you're not somebody who engages in the profession of journalism, are you? He says, well, I run a media... Objection as to form. I run a media company that by definition in our work in media also includes an aspect of journalism. So am I a journalist? It depends on who's asking and what we're talking about. They say, okay, well, it doesn't. It actually depends on what you do for a living and how you report on information that you report on. Do you understand that? He says, sure. So who was the source of information about the DNA report? Now that his journalist front has been torn apart, they ask him again. He says, I don't recall. Now he's forgotten. Is it that you don't recall, or is it that you're refusing to answer the question? He says, my answer was, you asked, I answered. You can answer the question. He says, I don't recall. So I'm going to mark this question, and we're going to reserve our right to take it up with the judge, because I think it's clear from the record that it's not the witness doesn't recall, but it's that the witness is refusing to answer the question and understands he cannot meet any criteria for any sort of privilege that would allow him to avoid answering the question. And on break, I'll decide if we're going to bring it up with the judge now or at a discovery hearing. I was just making a blank just to make a record. Gavin, take this down. I do want to make a record that the conversation we had earlier, where I asked you questions about the source of information who gave you the exclusive on the DNA report, I feel pretty strongly that we have a good basis on which to have a court compel you to provide us with that information. Okay, so they literally told him in the deposition that they were going to submit this. And we will ask the court to compel that you do so, which means that if a court does compel you to do so, I'll have to call you back for another day. I don't really want to call you back for another day for another question. Any chance you've changed your mind and you're willing to divulge the source of that information before we go? He says, I literally said I don't recall. So instead of coming clean and saving himself the time, he once again reiterates and lies that he doesn't remember. There is a person. Do I recall that person? No. Okay. He says, generally though, even if it was, it could have been the judge themselves. I wouldn't tell you. So I'm sticking on that point because of the profession I'm in, but genuinely with this particular situation, I don't recall. But if you want to, we could continue it further because, this is a bump in the road I'm going to have to get over at some point because this is a sticking point no matter who it is. It could be my mother. It could be God from heaven who told me I wouldn't. So, okay. Obstructing justice here. Well, that's all the questions I have unless Ms. Dixon, do you have any questions for the witness? Just to be clear, you're asserting a journalism privilege. Say we are now off the record. The time is 5:28 Eastern Time. Thank you for your time. Blase Bleezy. Okay. We'll continue. Exhibit D. What is this? Document title, Real One of One TV on X. DJ Akademiks says he doesn't respect Roc Nation for going so hard after blogger Milagro with their Megan Thee Stallion lawsuit, while not having the same energy for Nicki Minaj and others with bigger platforms. This is from Monday, August 4th. So they're quoting a platform or a user on Twitter who clipped up the DJ that don't spin for his disparaging of Roc Nation. Okay. Exhibit E. This here is an Instagram post from September 15th, just last week. This is of the DJ that don't spin, divulging the contents of his deposition from Zoom. Roc Nation and Meg Thee Stallion lawyers tried grilling me in a deposition because I don't believe Shorty. Bruh. And that's from August 23rd. They show more posts from his page. Another clip. Exhibit F. This is from 2022. Breaking, it was revealed in court a few moments ago that Tory Lanez's DNA was not found on the weapon in the Meg Thee Stallion case, although it had not been revealed in court because court hadn't even started. This tweet has since been deleted. He claims he deleted it because everybody became investigators and journalists when he at times invokes the title of journalists. Can't make this shit up. Exhibit G. Milagro, breaking. It was revealed in court a few moments ago that Tory Lanez DNA was not found on the weapon in the Megan Thee Stallion case. Now, one could say that she copy and pasted his tweet, or one could say that they both were copy and pasting from the very same source of what was needed to be disseminated to the public. I cannot say one or the other, just saying. Exhibit H. This is transcript of Sean Holly in court. And remember, Sean Holly was at one point representing Tory Lanez until she said, hey, you doing some shit that I cannot co-sign. I've given you my legal professional advice. You will not adhere to it. Therefore, I must move on with my life. So it says here, I can say to you that I am reading, that in my reading of what DJ Akademiks, again, I don't know who that is. I don't know that any of our jurors will know who that is or really what he has tweeted. I don't even know the medium in which he operates, but what he said isn't correct. What he said is that the DNA was not found on the weapon, and in fact, the swab of the gun indicates inclusive that there were 4 contributors, and the swab of the magazine indicates that Mr. Peterson was excluded. So what he said is incorrect. So if he had seen the document as is suggested by the people, then he presumably would have gotten it right, but he didn't. So it's just important, I think, for the court to take into consideration both aspects of the people's motion, really, the context in which all of these things are happening and the interest in this particular demographic and the manner in which they communicate, which is, again, I'm calling this Black Twitter. But because of that, the court is correct. A nexus cannot be made because there is just all of this chatter among people in their 20s who operate in a medium that is almost inherently unreliable. So that's what I have to say about that. The court, I understand all of that, but how do you explain Exhibit 17 and 18? Those are clearly comments about the evidence, about the discovery, and that's a violation of the order. So I can understand why Sean Holly got rid of that nigga or got rid of herself in his case, because it's like, hey, I'm fighting for you, but you out here communicating with these motherfuckers to put out public smear campaigns, and I ain't advising you to do that shit. She says, well, only in that what what blank is saying is untrue and it's silly gossip and posturing. I mean, it's not speaking to the evidence because it's not true. So what if Mr. Peterson tweeted that we just received evidence that there's a video that someone else did this? I mean, that would not be true. So what is being set forth initially by DJ That Don't Spin is untrue. And a response to that, embracing it, adopting it, suggesting that it might be true is also untrue. So, you know, I agree that it's messy. All of it is. This entire field that we're talking about is messy. And I've been battling with it from the start, not necessarily because of my client, but in part because of Miss Pete as well. Okay? Because both of them have made public statements on social media, right? Protecting witnesses from being thrust into the public light in a high-profile celebrity case and from potential harassment from the media and respective fan bases is a legitimate government interest. And protecting the victim from being contacted by the defendant or harassed either directly or indirectly in violation of the terms of the stay-away protective order is a legitimate government interest. So it's concerning to me that despite this court order afterwards, the defendant was unhappy with it and clearly took it upon himself to violate the discovery protective order. This is the DA. The exhibit in 17 and 18, I think it is absolutely clear. The act is telling no lies is in reference to the series of tweets by Mr. No Spin. So I guess Tory then came and did they try to corroborate that he was telling the truth? Exhibit 8. Mr. No Spin indicated that the DNA report indicated inconclusive on the gun. There's no reason why this individual would have obtained or I had that information short of being privy to the discovery. There's also a statement by Ak where he says, I saw the doc myself. It literally said it was inconclusive in finding Tory DNA on the gun. Again, that is Exhibit 8. So you have the defendant the following day validating these tweets, and then he himself responds to another article by Rolling Stone journalist indicating that he's looking at this document himself, and any questions about these tweets by Ak as being false is not true because he's looking at the documents himself. So he's validating these tweets. He's essentially directly and indirectly acknowledging the contents of this report that is absolutely a discovery protective order violation. The purpose of him doing that was to spin the discovery, spin the evidence in this case to vilify the victim, to strike doubt on the people's evidence on this case, on the witness credibility, and that was before it could be presented properly in a trial proceeding. These are all things the discovery protective order is meant to safeguard this type of behavior. And the defendant went out of his way to spin, to distribute, to disseminate this discovery and weaponize it to harass this victim. Not just to harass, but to impact the impartiality of a fair jury trial. So they even felt like he was trying to fuck up the jury pool, fuck up the jury with media so that they would either have to get new jurors or, fuck up to the point of a mistrial or something. And that is why we have these protective orders. And I'll leave it at that because there's additional discussions we can have about the criminal protective order. But as to the discovery protective order, I think the violations are clear here. And I think the courts noted that it's beyond compelling circumstantial evidence that there is a violation, direct evidence that he's violated it. Since the last court date, it was apparent that there were some leaks of part of the discovery to media or to members of the public. Namely, there was an individual identified as Milagro Grrrls, district attorney here. DJ Don't Spin has made additional comments that he had access to the police report. Again, we're trying to ascertain the sources of the reports or the source of the leaks at this moment. But my concern, obviously, is the way the leaks are being disseminated. They are being extrapolated in a certain way to mislead, in my opinion, the state of the evidence. I do have concerns about invested numbers of the public once this trial starts, trying to subvert the fair administration of justice when this does go to trial. And I think it's just for the court's edification that the court is aware that these are issues that are occurring behind the scenes. All right. Exhibit I. This is email correspondence with the DJ that don't spin. Good evening, Mr. Allen. I wrote to follow up on my September 2nd email. I think this was a failure to appear for deposition. He wrote them saying unable to make deposition today. I wrote to follow up on my September 2nd email. As I mentioned, we anticipate promptly raising this issue with court in the District of New Jersey. Please let us know no later than 5 p.m. tomorrow whether you expect an attorney will represent you in connection with our forthcoming motion, and if so, his or her contact information, given that you proceeded with your deposition in the absence of counsel. If we do not hear from you tomorrow, we will assume you are proceeding on this issue pro se, and we'll file our motion Monday. We will provide you with a copy of that motion and any further instruction from the court thereafter. So this is after he took his deposition. They're saying, hey, you showed up, you didn't have any lawyer, and we're just making sure that you have no objections to what was discussed in our deposition. If so, we will move forward by contacting the Court of District of New Jersey. Good afternoon, Mr. Allen. During your deposition, you declined to respond to certain questions asked on the basis of the journalist privilege. We intend to raise this issue with the court in the District of New Jersey, but would like to meet and confer with you on this issue to determine whether it can be resolved without court intervention. They tried to give him another chance. Please let us know if you have an attorney that you expect will be handling this meet and confer and any motions before the court. If so, please provide his or her contact so that we may communicate with your counsel. This is him responding to their email correspondence previously. Exhibit J. Another tweet. Aiden Ross reveals to Akademiks that Megan Thee Stallion, Rock Nation lawyer, sent a mariachi band to his house to try and bait him out to come outside so they could serve him for a deposition. And Akademiks says that Rock Nation have asked a federal New Jersey court to have him deposed. So every step of the way, he has been disseminating their private communications to the public. This comes from his No Spin TV account that he does not run, but the Grand Wizard Asian does. These are a string of comments underneath it with people you see what's going on here. Influencing public opinion, basically. Damn, cuz it's a long. That's it? Oh, that's everything. Cool. And finally, we have this document here from Megan's legal team to the judge in New Jersey about the DJ that don't spin. It says, Dear Judge Kirsch, this firm represents Megan Pete, petitioner in the above referenced matter. Pursuant to the court's September 17th, 2025 order, Ms. Pete's motion is set for October 20th, 2025. The motion, however, relates to discovery in the underlying Florida action, Pete v. Cooper, which is set for trial on November 17th. That is when the trial will begin, November 17th. Accordingly, we respectfully request that the court expedite Ms. Pete's motion to compel and set resolution of the motion for no later than October 3rd, or as soon thereafter as is convenient for the court. Okay? So they're trying to get this moved up as quickly as possible so that they could also prepare for trial. Under the current schedule, if Ms. Pete's motion is granted, Ms. Pete will suffer significant prejudice as the parties would have less than 1 month to schedule and take the redeposition of Mr. Allen. Last-minute disruptions caused by deposition in the final weeks before trial are highly prejudicial. Ms. Pete believes Mr. Allen has valuable and necessary information relevant to the Florida action, and although Ms. Pete hopes for the prompt scheduling of any such redeposition, she is reasonably concerned that scheduling will be difficult absent immediate action by the court given Mr. Allen's lack of communication to date. Okay. Setting time and place for the completion of taking the deposition as soon as possible. As such, Ms. Pete respectfully requests that the court set a date for resolution of her motion earlier than October 20th, so she and opposing counsel in the Florida action are able to adequately prepare for trial. At some point, discovery must end so that the parties can determine the total universe of facts and all evidence relevant to a case. Ms. Pete has moved promptly to enforce compliance with the subpoena to Mr. Allen. Mr. Allen should not be allowed to avoid compliance with the subpoena simply because the clock is running out. Lest it be unsaid, this court will not view favorably any obstreperous or bad faith efforts by the deponents or counsel to run out the clock on the court's time. Ms. Pete respectfully requests that this court expedite ruling on her motion to compel so that she may have adequate time to prepare for trial. Okay? So all post-deposition actions, motions, and things of that nature, DJ That Don't Spin has no longer been compliant. He hasn't responded. He's been ghosting, but he's been online creating content daily. Okay? So she's now saying, hey, we need you to interfere. We need to get this scheduled quickly as possible. We need to set up a hearing for him to be deposed once again with the presence of the court, because they did it with just lawyers. He didn't comply. He withheld information and said, I will not speak on this matter without a court order. So now they say, okay, well, let's obtain the court order so we can move forward. We'll see how this goes. So yeah, man, This guy has basically been obstructing justice, withholding information, and trying to make this as difficult as he possibly can under the guise of either journalism or I have no connection to this, although Tory Lanez has literally sent him information to disseminate to the public, trying to get ahead of the courts to sway public opinion. They caught him in his lie of being a journalist versus a non-journalist, which he has confirmed he is not a journalist, but sometimes he will use the title at his benefit. I think that they're going to definitely get him to do this redeposition, but how will it go? Because remember, Tory Lanez was brought in for redeposition, and his lawyer said, we're not moving forth with this. So it was unproductive. Nothing came of it. So they're trying to make this difficult for Megan at every twist and turn as they can. Ultimately, none of this is going to fare well for Milagro, even if they don't get the information from DJ That Don't Spin. She's going to lose. But again, trial starts November 17th, so we'll just have to see how all of this transpires leading up to it, and if they could get this redeposition with the DJ That Don't Spin, and if it turns out to be productive because of the judge's presence. All right? Let me know what y'all think of all this down below in the comments. I know this is long, a 2-hour video talking about this shit. But be sure to like and share the video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider, and I will catch y'all on the next one. All right? Much love and respect. I'll see y'all top of this week. Tomorrow, my new record, Family Over Fame Freestyle, will be out. And yeah, man, I'm going to need y'all to support it. I'm going to open up the show tomorrow with the song so y'all can hear it. And I'm going to need y'all to activate Voltron. You know what I mean? But I'm going to see y'all tomorrow. Peace.
Ain't no way to stop it when a nigga poppin'. Pull up, start a problem, I got plenty options. Homies from the project, we the trending topic. I got bennies in my wallet, fuck your all I got is all I could get. Flooded the nine and I flooded my wrist. Tell me I rap for the glamour and glitz. Got on my shit, now they rent me on list. Filling my pocket, I'm taking a trip. Call me a genie, I'm filling my wish. When it come down to me and get in my bag, I gotta get it, I pay for the lift. I got a baby, we coming legit. Roll with the big dogs. I need my cut like fit now. Buddy got shot like Sim car. Married to the game like in-laws. Do what I please, move with the breeze, right to believe. Shawty, she love me, she coming to tease. Ready the haters, we cutting the weeds. Give me my space, oh man. Got me a taste, oh man. Flooded the face, I'm running the race, I cover the bases, all down. Nigga, don't try me, I'm on my square. Cardiac diamonds, I want me a pill. Treat all this money like I got a meal. Everything closer than it might appear, yo. Bitch, I got my mask on now, watch your germs here. I've been getting paid since the first time on my third tip. Popping on the net, fuck a local, I got turf here. Fucking with the squad, we gon' put y'all in some merch, yeah.